Hi guys, this is Erica from Gokce Capital.
Now before I begin, be sure to subscribe to our YouTube channel and turn on notifications. We give Thomas Jefferson too much credit. He did not invent the lien. But because he is Thomas Jefferson, many believe he did. After all, Thomas Jefferson did invent macaroni, the swivel office chair, and the dumbwaiter. So surely he could have created something as commonsensical as the lien. Yet he did not. As with many of his great legal concepts, Jefferson stole the lien from his favorite victim, the Romans. Or to be more accurate, from civil law, the child of Roman jurispractice. But of course, Thomas Jefferson being Thomas Jefferson, he took this concept and used it to build something new. In this case, his nation's capital. But more on that later. For regardless of their origin, liens are something that every property owner should be aware of. And researching property liens is one of the key due diligence items that you will need to perform when buying land. So if you are a property owner or in the market, here are some of the top things you should know about property liens. Number 1, a property lien is a financial claim on your property by a creditor. And a lien can prevent you from selling your property until the creditor has received their allotted payment. Number 2, there are two kinds of liens. Voluntary liens, which, as the name would suggest, is a kind of lien that you, as the property owner, agrees to. The most common type of voluntary lien is a mortgage. But then there are involuntary liens. And this type of lien is usually placed on a property due to unpaid obligations. And it is this kind of lien that you should look out for when purchasing property, for involuntary liens are the liens that make it difficult to sell. Number 3, there are different kinds of involuntary liens. But some of the most common include mechanical or contractor liens. And these result when homeowners hire a contractor to perform home improvement projects and then do not pay the agreed upon payment. When this happens, the contractor is able to place a lien on the property to secure payment owed. Although perhaps the most common kind of involuntary lien is a tax lien. Tax liens are liens that are placed on the property to secure unpaid taxes. Most commonly local property taxes, but also the IRS can place a lien on your property for unpaid federal tax payments. And then there are judgment liens. These liens arise from court cases in which it was ruled that you owe money to another party. There are many different reasons why a judgment lien may be placed on a property, but some include settlements related to child support, unpaid credit card debt, or medical bills. Number 4, you can search for liens in public documents. So if you're looking to purchase a property, or you simply want to check whether the property you already own has a lien on it, you can do a search yourself, because most liens are of public record. To check your property, you can search the property address or assessor's parcel number in the county recorder or clerk's office. Sometimes the liens may also show up in the assessor's office. But of course, the most secure way to check whether liens are recorded against the property is to hire a title search from a title company. The benefit of doing this is that the title search will also check for other kinds of issues that may cloud ownership to the property. Number 5, you will likely need to satisfy any involuntary liens before selling. As I mentioned earlier, involuntary liens are the kinds of liens that can create a headache, primarily because lenders will usually require all involuntary liens be addressed before issuing a mortgage. And even if you are selling to a cash buyer, open involuntary liens will be flagged in title search and may make it difficult to get title insurance. Thus, the buyer may require that the lien be satisfied before proceeding with the closing. I will also make a quick note here that voluntary liens will be flagged in a title search as well, but they are usually paid by the escrow agent from the sales proceeds and typically do not pose a problem. The only exception here would be if the value of the property is less than what is currently owed. If this is the case, it will definitely be flagged by a lender and become an issue. Number 6, make sure a lien release is recorded for any paid debts. So it's not enough that either your seller or you as the property owner pay off an involuntary lien. Either you or the seller must make sure that a lien release is recorded to clear title. If this is your responsibility and you don't receive one of these releases within 30 to 60 days of payment, then you should contact the lender directly and ask when you should expect to see the release recorded. Most lenders will automatically do this, but sometimes, if the lien is on behalf of a small business, it's possible that the business owner is not aware that they need to do this once they have received payment. This is why it's important to follow up with the lender if a release does not show up in public records within a reasonable time frame. Number 7. Most liens are recorded and available in public records, but there are some liens that are not recorded. The most common kind of unrecorded lien is a municipal lien. So these liens often occur when the municipality undertakes some kind of work on behalf of a property owner. So for example, if a property owner owns a parcel of vacant land and is not maintaining it, the municipality may come out and mow or otherwise clean up the lot and then place a lien on the property for recompensation. And it's important to understand that some liens are unrecorded because title insurance won't protect against such liens. So if you are buying a property, even if you have a title search done and pay for title insurance, there is still a chance that some unrecorded liens may exist. Because the most common kind of unrecorded lien is a municipal lien, one way to protect yourself is to order a municipal lien search. This is typically separate from a title search, but you can inquire with your title company as to how much a municipal lien search will cost. But let's return to Thomas Jefferson. At a meeting on September 8, 1791, Jefferson and a few other founding fathers faced a unique problem. They had too much land. But Jefferson, of course, had a plan. He and the Capital Commission wanted to transform some Maryland acreage into the nation's capital. And Jefferson wanted the land to be held by a series of small landowners, not a few aristocrats. The problem? The small farmers and tradesmen that Jefferson supported rarely had enough cash to pay for the development of a property. Credit was also hard to come by, since the credit industry was still small and lacked faith in the new nation's currency. The situation was made worse by a ban on British imports that drove up the price of materials and thus construction. In such an environment, how could the founding fathers encourage builders to work on a task as expensive and risky as building a new city? The answer was the mechanics lien, codified in the state of Maryland's 1791 mechanics lien law. By giving the builder a stake in the new development, it encouraged masons, builders, and architects to move forward with the construction of the city. And we have this law to thank for the rapid development of both D.C. and the country as a whole. And if you have ever engaged in a construction project, this law and its successors in other states have affected you, whether you knew it or not. So do you have any stories about property liens? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down properties at gokcecapital.com/listings. Finally, don't hesitate to reach out with any questions. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.